bringing in settlement negotiations.
Well, you brought in you said you never offered to sell them. You did offer to sell. Saying that the value of the asset is less than $1 million. That's what she's saying.
I can't,
He's
Judge,
saying the value
he's
of the
trying
asset.
to get me to comment on the value of the asset
And
of
Mr.
one of my
Polsenberg,
clients
I don't want you to,
suing the other. That's exactly what he's
Mr.
trying to
Polsenberg.
do to me today.
Mr. Polsenberg, I don't want you to go down that rabbit hole. Okay, we're gonna move on. Next up, page 8 of the calendar, and that's Brian Gallagher versus Affinity Lifestyles, Inc. Good morning, and let's go ahead and set forth our appearances for the record. We'll start first with the plaintiffs, then we'll move to the defense.
Your Honor, Wilson for plaintiffs. Good morning, Your Honor. Eric Pepperman, also for plaintiffs.
Hey, good morning, Your Honor. Any part of the
Good morning, Your Honor. For Milwaukee, I have Dan Polsenberg, Abe Smith, and Michael Rawlings, who did not check in. From Hutchinson Stephan, he's bar number 5467.
No, I'm from Michael D. Rawlings, PLLC.
Sorry. Living in the past.
5467.
And that's from Milwaukee.
Yes.
Your Honor, Joe Reynolds on behalf of Hanna Instruments, and I'm from Hutchison and Stephens.
There you go.
And Chad Fears on behalf of Hanna also.
All right, okay, we have one more on the line.
Good morning, Your Honor. Joel Ledoux on behalf of AffinityLifestyles.com Inc. and Railwater Inc. Thank you.
And good morning, Mr. Oldham. And I think that covers all appearances, is that correct? From what I can gather.
Once anybody wants to talk.
Anyway, let's go ahead and get started. It's my understanding we have, let me see here.
Milwaukee's emergency motion for stay and Hannah's joinder and separate motion for stay.
I understand. Okay, Mr. Polsenberg, you have the floor, sir.
Thank you, Your Honor. So this is our motion for stay. Now, let me jump to the end. I'm going to ask you to move everything, give us a stay for 45 days, move everything back to give you the opportunity to look at that. Mr. Kemp in his opposition says, well, that's fine. They can have 45 days. I don't want to execute on anything except their cause of action, Milwaukee's cause of action against its insurance company, Liberty Mutual. Now, that's not the way stays work. You either grant a stay of execution or you don't grant a stay of execution. You can't select which assets to do. And under these circumstances, there should be a stay of all execution against Milwaukee because it is not, first of all, not in a position pending appeal under 62D Delta to be able to post bond for the full amount. And that's where the Nevada Supreme Court just in 2005 adopted the Seventh Circuit test under Dillon, Dillon. That's the Seventh Circuit case. The Nevada case is Nelson versus Heer, Heer, where you don't need full security. And there are some circumstances where you don't need full security, and one of them is here. And that's part 5 of the Nelson's test, whether the defendant in such a precarious financial situation that the requirement to post a bond would place other creditors of the defendant in an insecure position. We've gone even further in our proof for this, and they don't seem really to contest it, that we would not be in a position to post a bond if they were allowed to execute against us, Milwaukee. There would not be much left of the ongoing operation. So to preserve the status quo, which is what the Nevada Supreme Court has taught us, is the purpose of a post-judgment stay. You need to keep things as they are. Keep the company operating and running, and you do that by, you can put orders limiting our ability to get rid of possessions, and you make sure that they're not prejudiced the same way. We're not going to get rid of any assets. They wouldn't be in any better position. They come in now and they fight us on the standards by pointing to liberty. A judge, I'm clearly under the impression that Mr. Kemp is trying to put me in a conflict situation by conflating both the insurer and the insured. And the Nevada Supreme Court in State Farm versus Hansen said I have obligations to both of them. By the way, I think that was wrongly decided. But that's the law that we're living with. So it doesn't hurt them not to go ahead with an immediate execution of this cause of action. It doesn't. It preserves the status quo. Milwaukee is not going to assign it to somebody else. You can order Milwaukee not to assign it to somebody else. And there is ongoing litigation right now in front of Judge Mahan in the federal court between Milwaukee and its insurance company to find out what the coverage is. So this is all being taken care of. There are other avenues that plaintiffs have if they want to be involved in the coverage issue. But for them to come in here and take this.
So why are they litigating in federal court to find out what the coverage is? I would anticipate that would be readily available to an insured.
But that what would be readily available?
The limits.
No, there's a dispute on what the limits are. Remember, we're talking about 16 instances here, plaintiffs here. And I believe that the dispute is the definition of occurrences. That's as far as I can go on that.
And we're not in that case, Your Honor. The plaintiff.
I understand. I was just looking in the general sense, why would a insured be fighting its insurance company to determine the available coverage?
Yeah, because there is a
The insurance
dispute.
company sued the insured. It went the other way around. Yeah.
I never said anything different. I have it right here. In fact, if your question was why were they in federal court, I would have guessed that because the insurance company filed first.
Yeah.
So there is a dispute.
No, I understand. That's really kind of interesting. I'll leave it at that.
Right. So that's all being taken care of. Mr. Kemp doesn't need to take the cause of action to figure out what the limits are. That's being handled. He can monitor that. He has other remedies available along those lines. And so there's no reason to rush in and say, let me take this one asset. Well, what if you were to say, yeah, I'm inclined to give a stay against a manufacturer, and plaintiffs were to say, okay, they can have a stay against everything except their manufacturing equipment. We want to take that. What if there was a judgment against me, and Mr. Kemp would say, he can have a stay of everything, but I want his computers and typewriters. That would keep me from being able to practice law. So the question is there a stay or isn't there a stay? We meet the requirements under Nelson for a stay without full security, and I think we have an even better. Let me go back to.
Here's my question, though. I mean, I'm looking at it through this lens, and tell me this: would this be in the best interest of your client as far as this case is concerned, or any case? Because I'm just looking at the very end on page 9. The plaintiff says, this is their position. They said plaintiff's present intent is to execute only on a bad faith rights, and plaintiffs are willing to enter in a 45-day stipulation that the execution, provided that the bad faith rights are excluded.
And that's what I'm talking about.
No, I kind of get it, but wouldn't that be in their best interest?
No,
Why not?
it's not the best interest to selectively take one of Milwaukee's rights. Milwaukee is sophisticated, is already litigating against its insurers. And I don't like the way they're taking the asset either, Judge. This is not like we used to do back before the Malco case, where plaintiffs would give the insured a covenant not to execute in exchange for assigning the bad faith rights. They just want to take the bad faith rights and still have the right to execute against Milwaukee. So this is not the situation that you as a practitioner were used to. Plus, I don't like the way that they're doing it. They're saying they're going to take the cause of action, the chosen action, and sell it at a sheriff's sale. I imagine they would bid for it themselves, picking it up on pennies for the dollar, maybe even pennies for the $10,000. That's not a reasonable way to assess the assets. There should be a stay on everything, preserving the status quo. My client, Milwaukee, wants to preserve the status quo, does not want them to take this asset, whether it's a key asset or an aside asset. Clearly, plaintiffs and Milwaukee think it has value. So under these circumstances, and Judge, this is a lot to decide. So I would suggest to you that you do the 45-day stay for everything. And if you need an evidentiary hearing to determine the conditions of the stay.
Why would I do an evidentiary hearing? And the reason I bring that up is this: I always get these requests for evidentiary hearings.
And I'll tell you what.
I know you will, but my point is this, and it's fairly clear. First and foremost, everybody wants an evidentiary hearing today. I don't know where that came from, right? They just do. But secondly, I'm in trial, right?
Right, that's what I'm saying, if we're looking at 45 days. But the only reason we present an evidentiary hearing, and we did one of these in front of District Judge Douglas Hernand on a stay once, where we showed, here are our assets, we can't post a bond, preserve the status quo by, we won't post a bond, but we won't divest of any assets. And Judge Herndon agreed with that. And that follows the Seventh Circuit line of cases under Dillon. But there's even something else here, Judge. Our Rule 62B, Bravo, is different from the federal rule. It allows you to grant stays without any security pending post-judgment motions. And you still have post-judgment motions in front of you to be determined. And that's critical. You notice Hanna says that the way you rule on this could affect whether they go into bankruptcy. I think you need to determine what the amount of...
And explain that to me. How would that impact, or why would that force someone into bankruptcy when I'm looking here and the plaintiffs is taking a position? I should say their intent is to execute only on bad faith. So how would that throw?
Well, now it's only bad faith, and he's only giving us 45 days on everything else.
Right.
And Hanna's proposal is that they post $1 million because they apparently have $1 million in proceeds on their policy. I don't have, as far as I can tell, $1 million of proceeds under my policy, which is why, in part, there is this dispute. So I think we qualify for a stay of everything, but under 62B, you should let everybody have a stay without any security in the now nearly unique Nevada rule until you decide the post-judgment motions. And under all those circumstances, I think that I have a lot of arguments about the Rule 8 factors. I have, but I think that all goes to, remember, the Rule 8 factor is whether it would destroy the object of the appeal. If you don't grant a stay, they will be able to destroy the defendants here, Hanna and Milwaukee. At least they wouldn't be able to keep operating. So why would you need an evidentiary hearing? So we could show the financial impact of not getting a stay. I think, Judge, it's a binary state on a stay. I think it's a toggle switch. You either grant a stay or you don't grant a stay. If you're going to be selective and let them have particular assets and not other assets, I don't see anything under Rule 62 that allows that. I'll have another request after you rule, depending on how you rule. Okay. Thanks, Your Honor.
Mr. Reynolds, sir.
Good morning, Your Honor. Joe Reynolds on behalf of Hanna. Hanna filed a joinder with Milwaukee's motion, and so to the extent it applies to Hanna, especially with respect to this court's analysis of the Nelson factors and the fifth factor in particular, we join in that request. And jumping to the end, as Mr. Polsenberg did, we request at a minimum that this court issue a stay while it takes the motions that are pending before it under advisement. and until at least it issues a final enters a final written ruling on the pending motions. As the court's aware, April 4th is just 2 days away. And so we ask that at a minimum today. We are looking for clarity and for guidance from this court on how next to proceed, because we are somewhat shooting in the dark on the bonding and the stay issue. We'll ask
And when you say shooting in the dark, what do you mean? I just want to make sure I have clarity.
Well, right now, Your Honor, we have a approximately $38 million compensatory damages award.
Right.
That's jointly and severally liable, creates, joint and several liability against 3 separate defendants in this case. What is Hanna supposed to do in terms of its bonding obligation? Presuming, one applies to this case in posting a bond with respect to itself. We don't have clarity on that. And that is something that we're asking for in our pending motion before this court, as well as what Mr. Polsenberg argued. There are currently 8 post-judgment motions.
I just want to make sure I understand the clarity issue. What's unclear as far as the compensatory damage award or?
The compensatory damage award, there's still a pending motions that the court's taken under advisement on to amend the judgment with respect to prejudgment interest.
And so if I make a determination on that issue, that would give you finality and that would be clear. Is that correct? I just want to make sure I understand.
That is one of the points that we're looking for clarity. There's several $1 million related to those pending motions that are still outstanding. So we don't know exactly even what the final judgment amount would be given those rulings that the court's taken under advisement, as well as how the $38 million would be apportioned amongst the 3 defendants in this case. And we're asking the court to look at the totality.
Why would there be an apportionment amongst the defendants?
Your Honor, we believe that one, that would be consistent with Nevada law. NRS chapter 20.037 puts a cap, a $50 million cap on a total bonding obligation when there's multiple defendants in the state. If each defendant were required to post the full $38 million, you would certainly exceed that cap. That would lead to an absurd result. As well as going to due process under both the federal and state constitution, that's only fundamentally fair. And while Hanna has joined in Milwaukee's motion, Hanna is also in a different position as well. And I'd note for the court that the judgment pending against Hanna is not the result of an admission. It's not the result of a summary judgment motion, and it's not the result of a specific jury finding. The pending compensatory damage judgment was the result of a sanction that was directed by this court. We've already raised before this court a due process challenge in our motion for a new trial to hold Hanna now liable.
I don't mind telling you this. This is kind of how I look at it. Due process goes both ways. And what I mean by that is this: if testing is withheld, that impacts the plaintiff's due process rights. And I understand you said, Judge, look, you should have an evidence. You know what? We're in the middle of trial, right? And we had testimony and argument. We had testimony on the stand and we had argument by counsel. That's enough evidence I need there. Now, do I have to go into particulars and see what exactly the testing was and as far as the trial is concerned and stop the trial for a week or two to bring in? I'm not going to do that. I don't mind saying that, especially in a case that was as rigorously prosecuted and defended as this case. So I just want everybody to understand that. I don't find that compelling. I really don't, because at the end of the day, we know this. What does Rule 16 mandate? If you're doing testing, you got to produce it. It could be positive. It could be negative. It could be much of nothing. But you produce it so it can be tested from a due process perspective. And you don't sit and testify about testing that was conducted while I I guess the managing speaking agent on behalf of your client was testifying that there was testing done. That's a problem. I really do. And you know what? We'll see what the Supreme Court does with that. But I feel very strongly about that. Everybody wants an evidentiary hearing. And it's not, and it's in my understanding under Bahena, it's not required under all circumstances, you know? And so my point is this, right? That is what it is. And that's something that the Supreme Court will have to deal with, right? But continue on, Mr. Reynolds. I just wanted to point that out because at the end of the day, you're saying that there should be no bond posted at all. Is that what you're saying? I just want to make sure.
Yes, Your Honor. We join in Milwaukee's argument and especially, again, point this court to the fifth factor in the Nelson v. Hare analysis, in that this will place the party in a precarious financial position. We did attach to our motion an affidavit from Hanna's global financial officer that requiring Hanna to post the full $38 million bond exceeds Hanna's net assets. It will cause severe financial hardship to Hanna, where it will be contemplating seeking bankruptcy protection. Going back to the whole purpose of the stay requirement is to preserve the status quo.
This is kind of, and maybe I'm missing something, but why would why would Hanna or Milwaukee be object to, because it seems to me it would be in their best interest to potentially agree with the plaintiff's intent, and that would be to permit only execution upon the bad faith rights. Why wouldn't that be in the best interest of your client?
Well, Your Honor, for
all other matters being stayed, I just want to make sure I understand that. Why wouldn't it be best for them?
Well,
Because they're sitting here saying, look, we don't want to put them out of business, but they have a clear potential bad faith claim against their insurance company. And so it seems to me on that specific issue, there might be some common ground.
Your Honor, for the reason, again, we join and concur with Mr. Polsenberg's response to that question to the court. And I would add the entire purpose of a stay is to preserve the status quo. To the extent that there is a theoretical asset in a bad faith claim, we submit that that's contrary to public policy, that it's wedging an insured against its insurer. As a
well, I don't know about that. I mean, I actually, it's just the opposite, because from a public policy perspective, the relationship between an insurance company and its insured is akin to a fiduciary.
Well,
and so in essence, the insurance company should be looking out for the best interests of its insured, right? And so it's not like, and this is what I don't get, because I don't understand why a defendant would be bootstrapped with their insurance company when it comes to potential bad faith claims.
Your Honor, it is to the extent it's made a condition in order to seek a stay pending appeal. And that is all that Hanna is asking for, is to preserve the status quo while it seeks review of the proceedings before this court by the Supreme Court. And so to the extent that there is a bad...
Do you think this would be in Hanna's best interest not to, for example, I circle back to plaintiff's intent to execute only on the bad faith and are willing to enter into a 45-day stipulation, the stay execution. And here's my point. Potentially the 45 days could be changed, right? And so I look at it from this perspective. What would be in the best interest of Hanna?
Your Honor, the answer, proper right now, no. And again, I submit that's an improper conversation in order to seek a stay pending appeal, and that to the extent that there is a property interest or a right in a theoretical bad faith claim, that's not security, and that's not surety to preserve the status quo pending appeal. To the extent that that is an asset that can somehow be sold in a sheriff's sale.
Are you saying this would be improper? I just want to make sure I'm
Yes.
clear. You didn't let me finish.
Oh, sorry. I apologize, Your Honor.
Yeah. Are you saying that it would be improper for your client to agree and assign its bad faith rights to the plaintiffs in this case?
Your Honor, in the context of this pending motion, yes. That is to the extent that that is a tangible asset or a right, a party should not have to forgo an asset or relinquish a right in order to seek a stay to appeal to the Nevada Supreme Court. And that is the context of my response, as opposed to.
Because would that potentially create a conflict?
Judge, can I address some of these?
Absolutely.
Mr. Kemp? So he said that I don't have to sandbag him. Let
Yes.
me go to your thing first. Is it in the best interest of the insured? Does that create a conflict? Yeah, I think Will's trying to create a conflict.
Well, you brought that up in
I
your
did.
first statement, Mr. Polsenberg. I'll give you credit for that. You did.
So I
You didn't,
brought
I'm gonna let you run after, and I just wanted to make a comment. You didn't run from that. Go ahead.
Right, so I brought separate counsel for Milwaukee
Right.
here. So he can say, yes, Milwaukee wants to retain that right against the insurer. Milwaukee wants to. That's Milwaukee's choice. And there's already litigation on the coverage. So if the bad faith case is what the coverage is, then this is already going on. There's no reason for them to take that ethereal right and try to bring some other action. There is an action ongoing. If the bad faith goes beyond that, and let me tell you, this is where I'm not allowed to talk about things.
And Mr. Polsenberg, trust me, if you're not.
But
allowed-
I have
I don't want
Mike
you
Rawlings
to,
right
I
here.
don't want you to do anything that you're not allowed to do.
Right, but
I
I
really don't.
have separate counsel for the insured who will talk about, yes, Milwaukee wants to maintain these assets. They shouldn't just be able, plaintiffs, I'm pointing to plaintiffs, to take these assets.
Your Honor, if I may just say this, I'm local counsel in the coverage case. Milwaukee's doing everything it can to maximize its coverage in this case. It is essential to Milwaukee that it obtains its maximum coverage because it's Milwaukee's entire livelihood. I don't think what we need is the plaintiff injecting themselves into that process and coming into the court and probably making arguments that conflict with the arguments that Milwaukee's already making. For instance, Milwaukee still denies liability in the case, but the plaintiff's going to walk in there and assert otherwise. It makes a very sloppy case for us to try to protect our rights on that coverage if somebody else comes in.
Couple other points. You asked about the evidentiary hearing. My argument about the evidentiary hearing is different from Joe Reynolds' argument about the evidentiary hearing. I'm just talking, I know how you ruled.
Right.
I'm just talking about if they dispute. I have the affidavit declaration, old guys say affidavit. I have the declaration of the president of Milwaukee talking about how this judgment exceeds the total revenue, the annual profits, the net worth of the assets. If they don't want to, if they don't dispute that, I don't need an evidentiary hearing. I have a prima facie
And
case.
I would anticipate they probably don't dispute that, but go ahead.
Very good. Then I have a prima facie case of a Seventh Circuit stay under the Nevada case of Nelson. So under those circumstances, you wouldn't need to do an evidentiary hearing unless you wanted to narrowly tailor any order you imposed on Milwaukee on its ability to, limiting its ability to divest any assets, including this cause of action. Why are we in such a hurry? Do they think Milwaukee's going to assign this cause of action to somebody else in the next 45 days? The purpose is, I've said it, Mr. Reynolds said it, the Supreme Court in Nelson has said it, the purpose of a stay pending appeal is preserve the status quo. If they don't have an ability to collect, they don't automatically get an ability to collect. It's to preserve whatever's going on. So let's just stay everything. And I keep saying stay on appeal, but yes, under 62 Bravo, you still need to figure out, Judge, what the amount of the judgment is. There are offset issues. There are interest issues. I've raised the fact that I don't think Milwaukee can be held strictly liable. You haven't ruled on that. I've seen your facial expressions for 40 years. I'm not holding out an awful lot of hope on that one. But on the others, you do have to figure out the rest.
I know, I do. That's why I agree with you in that regard, Mr. Polk.
So under all those circumstances, I think we are entitled to a stay under the Seventh Circuit guidelines adopted by this court, the Supreme Court in Nelson versus here. This is not a situation that we can just bond it. I mean, Hanna raises that plaintiff's counsel probably has a conflict and they're trying to get, I'm not even going to go there.
There's no need to.
Right, because conflict's an issue I can see on both sides here. But if you want to preserve the status quo, you don't let them have execution. You stay at all, Judge. You don't give them the asset they want to execute now, and then on their stipulation, give them a 45-day stay. Really, we'll be back. Let me do that. Let me raise the point that I said I was going to hold off on. If you don't give a stay, I need an interim stay from you because I'm going to the Supreme Court.
I understand.
Thank you, Your Honor.
You're welcome. Mr. Reynolds, I don't want to cut you off, sir. You have the floor. Let's go back.
Thank you, Your Honor. And again, we join with Milwaukee's comments in that respect. And again, I note for the court, and this is in our motion, and now we're short on time. Hanna is a family-owned, a privately owned business. Has 116 employees in the US, and certainly it has affiliations throughout the world. But it's certainly under our $1 million request. The Nevada Supreme Court, again, in NRS 20.037, puts forth a guidepost for this court. And this is a relatively new and untested law, but it was enacted in 2015, and its very purpose was to ensure that smaller businesses do not go under while they are pursuing an appeal to the Nevada Supreme Court. And again, in the affidavit that we've attached to our motion, to allow or require a full posting of the $38 million judgment that's pending right now would cause severe financial hardship and distress. It would exceed the net assets of Hanna. And again, at a minimum, we ask that the court impose an interim stay while it takes this motion in this matter under advisement until it issues and enters a final written decision.
On the pending matters. On the pending matters.
Yes, Your Honor.
I understand.
And with that,
And beyond that, so that we can go to the Supreme Court this time.
and as Mr. Polsenberg just suggested, and we do argue this in our motion, and beyond that, depending on what this court may decide, if it's necessary for us to pursue writ relief at the Nevada Supreme Court. And with that, we'll stand submitted, Your Honor. Thank you.
Thank you, sir.
Yeah, Judge, I think it's pretty ironic here that plaintiffs are taking more efforts to protect Hanna as a business and Milwaukee as a business than their own attorneys are. We have offered a stay for 45 days that will completely protect Hanna. We can't execute on any of their assets, none of their real property, none of their bank accounts, none of their payrolls, none of their pieces of equipment. We've offered that. Okay, they don't want that. They don't want full and complete protection because they want to argue that there's some kind of irreparable injury because they don't have that protection. That is the only injury they've argued. Okay, what this really is this is a motion to protect the insurance company from having to do what every insurance company has.
Yes, I'm gonna object to that. There's the conflict accusation. I brought separate counsel from the
I can't argue. I
insured.
said-
You interrupted me.
I did not interrupt you one single time.
Oh, please, sir.
I did
But
not-
gentlemen, come on. And now you know what I'm going to do, right? I'm going to listen to all
Tell
of
me
you.
to sit down and shut up.
No, have I ever done that, Mr. Polsenberg? No, I haven't.
You're
I'm
gonna
not sure.
nicely say something that has.
No, all I'm gonna say is this, I'm gonna listen to everybody.
Yeah, but this is inappropriate, Judge. He's trying to say this is a conflict that I'm looking out only for the insurer. I have brought separate counsel from the insured who has said what the insured's intent is in seeking this protection.
I understand, and the record notes that.
In your
How
honor,
about that?
I join in the objection. Thank you.
Okay, you're welcome. Mr. Kemp, go ahead.
So Judge, these two defendants are both insured. One's insured by Liberty, Milwaukee. One's insured by Hanna. That's Hanna. I don't know that the insurance amounts are relevant, but the insurance amounts are large. We made offers of judgment to both defendants to settle the case for pretty minuscule amounts. For example, the Hanna offer of judgment was $3 million.
I saw that. I was kind of surprised.
The insurance company made the decision not to pay that. The insurance company put its insured in this jeopardy. The insurance company decided, let's roll the dice because we think we can win this case. So now here we are at the point of the case where the insurance company is contractually obligated to step up and post the bond because it made a miscalculation. So what they're trying to do is they're trying to protect the insurance company from having to do that. That's exactly what they're trying to do. Okay. And I'm in a position where I just want to pursue the bad faith rights. Now they say, oh, well, we want to keep them so we can assign them to the plaintiffs later. What they want to do is they want to keep a bargaining chip in their portfolio, even though I have a judgment in tens of millions of dollars. They want to keep an asset and then somehow or another negotiate it or sell it to me. Well, there's a couple problems with that. The first problem is we don't have just one case. If we had just one case, the Gallagher case, ignore the plaintiffs, that might be an option. But in this case, if as soon as they sell me those bad faith rights, the insurance company voids the duty of defense for all the remaining cases. So all the remaining cases are implicated. I don't want to put the defendant in that situation. So again, I'm looking out for the best interests of Hanna and Milwaukee because I'm trying to find a way to actually, this is the ultimate moment of truth for the insurance company. If there's the stay that we propose that protects all of Hanna's assets, all of Milwaukee's assets, and just allows an execution on the bad faith case, the insurance company has a pretty hard choice here. Should they continue to commit bad faith and not protect their insureds? Should they continue not to take responsibility for their decision not to accept the minuscule offer of judgment? Or should they just post the bond?
And here's my next question, Mr. Kemp, for you. As far as the offer of judgment that was made in this case, was that within the policy limits?
It was, because remember, I offered $3 million over multiple policy years because we had Mr. Belsky 2018, we had Haley and the Gallaghers 2019, and we had the other four plaintiffs 2020. So there is absolutely no argument that they couldn't have paid those judgments. And that is an indisputable fact because in the second case, which would be the Hunwartson case, we actually settled with Hanna and Milwaukee for similar amounts. So the insurance company stepped up in that case because they saw that they had committed misconduct in the first case. So what we have here is an effort to protect the interests of the insurance company, not the interests of the defendants. And, Mr. Polsenberg says he's got a conflict. Well, that's his problem. That's not my problem. My problem is to try to construct a stipulation here that will effectuate what I've said our intent is, which is not to execute. We don't want to own a meter company. I've said that in open court. I've said that to all these people. But we do want to pursue the bad faith rights. And the reason we want to pursue the bad faith rights is that is the only way this litigation is ever going to get resolved, is if the insurance companies see that there's a serious threat that they're going to have to pay more than what they want to pay, which is basically nothing. And so I proposed a 45-day stay. That just didn't come out of thin air, Your Honor. We have the third case, the Wren case being tried in front of Judge Hardy on May 28th. Like I've already said, we were able to resolve our differences in the second case with Hanna in Milwaukee. Hanna brought in new counsel that we've had a lot of dealings with in the past, and I think they take a different view of it than the previous Hanna counsel did. But for whatever reason, we were able to resolve it. We think there's a reasonable opportunity we can resolve the third case with them, but we think we got to get past this hurdle. And this hurdle being to get the execution going on the bad faith rights. So I think we've made an extremely generous proposition to them. And I see, I just can't imagine the chief executive officer is going to stand up and tell the family that owns this family business, oh, the plaintiffs offered to stay any execution on our real estate, on our bank accounts, on any assets we own. But we refused that because we want to protect the insurance company that screwed us. Okay. If that's really what's going on, great. But I just can't see that truly is happening. What's truly happening here, Your Honor, is they're throwing up the company and its assets as some sort of sacrificial lamb, making these ridiculous arguments that they're going to be insolvent or they're going to go out of business or I'm going to run to Rhode Island and do executions, which we haven't even started. You have to file it there. They get an automatic stay. They have the right to seek a stay there. There is virtually no possibility as things now stand that this scenario of doom and gloom will ever happen. But it especially won't happen is if we enter into the stipulation, which I'm proposing. And so for that reason, Your Honor, I think that's the approach that the court should take because there is absolutely no irreparable injury from us executing on those bad faith rights. Absolutely none. Mr. Polsenberg hasn't addressed it. All he says is they don't want to sell them. Well, that's fine. They have a large judgment entered against them. Something's got to give somewhere. Maybe they don't want to sell them. But what they really want to do is they want to use them as a bargaining chip in further negotiations. And that is really inappropriate. So they've got a real simple situation here. Either the insurance companies step up and post the bond, or we execute on the bad faith rights. And I think that's what should be done.
Mr. Parker, anything you want to add, sir? I don't want to.
I think Mr. Kemp addressed all of the comments or arguments made by Mr. Polsenberg. And I believe Mr. Reynolds as well. The only thing I wanted to comment on, I didn't intend to speak today, but Mr. Reynolds brought something up that I found to be self-serving and perhaps not even correct. Related to whether or not some form of evidentiary hearing should have been held during trials. And I know Mr. Reynolds was not there during the trial, so I'm not holding that against him, of course. But I want the court to know, because this is something we found out recently, last Friday, when I took the deposition of Laura Brown. And that was the person who Mr. Rasmussen indicated the testing was done and never produced.
I remember that. I did.
Just to support the court's position, because the court made the right decision, and I will tell you, hindsight is 20/20. But let me provide the court a little more support for the decision it made. When I found out on Friday that Laura Brown was actually brought to town during trial September 26th and was there until 28th with the intention of actually testifying on the 28th, of which of course she was never identified under 16.1. Additionally, that testing was protocol was created by Mr. Babcock. Again, we were provided that in accordance with 16.1. Additionally, Ms. Brown said the testing results were done as of March 20th, 2023, 6 months before we started trial. Again, in violation of 16.1. Your Honor, everything that we learned from Mr. Rasmussen, the violations of our discovery rules were supported, and all doubt has been erased in terms of what this court has done. The court didn't know this was going to happen, but the court made the exact right decision based upon the evidence we had. And the evidentiary hearing would have done nothing more than prove exactly what the court had already learned through the trial testimony of Carl Savaggio, the president of Milwaukee and vice president of Hanna, and Mr. Rasmussen's statements on the record before this court. So just to address what Mr. Reynolds said, for some reason I thought it may come up I'm glad I'm here to at least set the record straight in terms of what Mr. Brown testified to under oath last Friday.
Okay, thank you, sir.
Your Honor, I apologize. This is Kelly Evans. I represent Hanna, 7691. I was at the deposition Mr. Parker is referring to. May I just address that because I believe that's an incorrect and not a fulsome description of the deposition that was given. And if there are going to be arguments regarding the evidentiary hearing that should have been conducted during trial, there's a lot more to it than just what Mr. Parker said with respect to relevant facts that have come to light in both Dr. Babcock and Ms. Brown's depositions. So again, in fairness to these counsel who are arguing the motions today, which this issue was not part of, there's a whole lot more to the story that I'd be happy to put on the record if your Honor would like. We do intend.
And I don't mind telling you this, or I don't want to cut you off, but today I'm dealing specifically with the bond issue. That issue was brought up regarding whether or not there should have been an evidentiary hearing during the course of the trial. At the end of the day, and I think this is very important to really point out, under our system of due process, Rule 16.1 mandates that if there's been testing done, any of that, it shall be produced, you know, and you don't have to make the request for it, right? And so, and when you look at it from this perspective, and I think the Supreme Court will get it, you're putting a trial judge at a significant disadvantage during the course of trial if there's been testing done that was not produced. What am I to do? Am I to go ahead and then hold a hearing? Do I have to make a determination as to whether it's relevant? Do I have to consider hallmark factors? What do I do? Because the bottom line is this: if any party performed testing and didn't produce it, that's a problem. It really and truly is, especially during trial, right? And I had testimony from a witness that there was testing done. Then I had an admission, and I'll give Mr. Rasmussen all the credit in the world, because I'm not throwing him under the bus at all. He was very forthright and truthful. And he said what happened, right? And that's all you can ask from counsel. And so here I am in the heat of a significant, hotly contested trial. And I'm supposed to say, oh, time out, you know, and especially in a case that was as complex as that. It's my recollection. I actually went down and did, how many panels did we have come in? And how long did it take for us to select that jury? I mean, it was, and so now I'm dealing with that, and I know there was testing done. And the bottom line is it should have been produced. That's kind of how I look at it. Our Supreme Court might look at it differently, but there's a reason why I ruled the way I did. I just want everyone to understand that.
Your Honor, and I understand you articulated this before I get it. I'm just saying, if Mr. Parker is going to put evidence on the record today and representations, I'm happy to put the Folsom account. We also intend to file supplemental briefing regarding the issue, because what you haven't addressed is the nature of the prejudice that needed to be shown before the sanction was imposed.
Well, I can tell you this, we can be really clear. The prejudice is not producing the testing.
But if the testing is consistent with the testing was already produced, which it is, and that's the evidence.
That day has gone.
I understand.
I'm just telling you, that day has passed, because you're supposed to produce the testing during the course of litigation.
I understand, Your Honor. My only point, I don't want to argue this today.
Yeah.
I wasn't intending to do it.
I'm going to tell you what I'm going to tell you when the time comes, because I'll be candid with you. I think it's inexcusable, right? I really and truly do, because the testing, maybe it was beneficial, maybe it wasn't. But everyone has, it doesn't matter whether the plaintiff did testing or whether the defendant did testing during the course of discovery, and it wasn't produced. And now it's being brought up in trial that there was testing admitted to by a witness. That's a big problem. I don't mind saying it. And it goes to the entire integrity of our system, right? It just does. And whether or not that was it Miss Brown was going to be testified during trial or not, you know what? That wasn't the basis for my decision. It's really, yeah. And my point is this: if there's testing done, whether it's beneficial or not, it has to be produced, right? And especially when a witness admits it on the stand.
Right. We'll be submitting a supplemental brief. I understand you've articulated your looking for. I just want to make sure that you understood that I disagree with Mr. Parker's representations
And that's okay. No, that's okay. But my point is this, what am I supposed to do? Vet the testing at the time of trial?
Well,
Right?
again, I think the point that has been made repeatedly is that would have been part of what the hearing would have been about. But nevertheless, we'll brief it and.
And I don't mind saying this, and I feel, and the Supreme Court might look at it differently, but I think when you, because I don't mind saying, I've never seen testimony like that in my entire 18 years as a trial judge. I've had some fairly complex and sophisticated cases in this department. And when it comes to expert testing, produce it, right? You know, and let the chips fall. You know, maybe it's fine, maybe it's not. Was there a report produced? Was there not a report produced? Why wasn't a report produced? Why wasn't a witness identified? I mean, and there's so much there. But to say, look, Judge, you know, you spent 6 weeks selecting this jury. I forget the exact number of jury questionnaires that I had to vet and go down personally in front of the jury. What was it, 800, 900? I mean, I don't remember the exact amount.
1421, if I guess,
1,421.
I mean, I believe you went through.
Yeah, exactly. You know, and so, and the reason why I think that's important to point out, this was a complex case. It really was. And there were a lot of heated issues. There's no question about it. And I think as a trial judge, when you're in trial and an issue comes up like that, it'll be fascinating to see what the Supreme Court thinks I should do. You know, because in light of, because I had really two sources. I don't mind saying it. I had the witness's testimony. I had Mr. Rasmussen, who was forthright with his court. And I've always respected him for that, you know, and he's been in front of me many, many times. And so I'm not going to say anything negative regarding Mr. Rasmussen because I think he's a wonderful lawyer. I don't mind saying that for the record. And he just told the truth and let the chips fall. Let's go back to the bond amount. And
That's a good idea.
yeah, Mr. Polsenberg, because believe it or not, I'm in trial right now.
I know that, and I appreciate you. So I gave you the truncated argument first. So because I know you told us we had limited time, and this is.
But this is an important issue. Notice I didn't cut
It's
you
a
off.
very important issue. So let me start by doing Abe Smith's imitation of Dan Polsenberg.
Okay.
Okay, let me take Teddy's last point first. You're right, that has nothing to do with this.
Exactly.
As I said a half an hour ago, that has nothing to do with this. I'm not going to fight you on it because you believe strongly that what you did was right. And I brought up what I think is a bigger appellate issue, but it doesn't matter. Under the rule 8 factors, while factor 4 is whether an appellant is likely to prevail on the merits in the appeal, is only a requirement, as the federal courts make clear, that we have a good faith appeal.
I understand.
And we have a good faith appeal. You just said that a moment ago. And we have the right to have it heard without destroying the subject matter, which is the appellant in this case.
Now tell me, this is my question for you. Under the facts of this case, especially where there were offers of judgment, and this is where I'm gonna go to. There were offers of judgment made within policy limits. And I understand there might be issues regarding the viability of the company. Ultimately, whether to accept or object, I would anticipate this isn't a consent policy like you had at the medical malpractice type cases, right? And so my point is this, why shouldn't the insurance company post a bond?
Because there aren't available policy limits, because we're not talking about just one case. We're talking about 16 cases.
I understand, but I mean, as far as the total, why shouldn't the security, you know, because I mean, this is, and it might sound very fundamental, but ultimately, and a decision was made to reject.
Let me interrupt you.
Go ahead.
Okay, I wrote this down because Will was talking about the offer of judgment to Hanna of 3 million. You not only had that facial expression, you actually went, So it's clear that you were impressed with that argument on coverage. That argument is not in front of you. I can't make an argument on either side of that. You can't decide the coverage issue.
But I don't want to decide the coverage issue. That's in federal
You
court.
want to, Judge, I can see.
No. This is the issue I want to have some enlightenment on from you, Mr. Posenberg. There was offers of judgment made in this case, right? We can all
I don't-
agree. Whether offers of judgment made,
Yes, Your Honor, Mr. Polsberg knows because I attached him to the JOB motions.
okay.
I can't, Judge, I can't get into the coverage. issue.
Okay, but I'm not going into coverage issues. I'm not at all. I just have a simple question. If there was offers of judgment made and the insurance company decided to reject the offers of judgment, and we have an excess verdict over the policy limits, why shouldn't the insurance company post a bond?
Because they say that they do not have available proceeds, and that is being litigated in another case, Judge.
But my point is this, and it's really this simple. They say they don't have available proceeds. I really don't understand that because who are the insurance companies? Liberty Mutual, and who's the other? Yeah, right. And my point is this, I would anticipate they have reserves more than capable to post a bond in this case, right?
You're saying set reserves in
Well,
this case as opposed to
I'll say it-
company-wide
Well,
reserves?
I'll say it this way. They have assets available to them,
They're Fortune 500 companies, Your Honor.
right?
Judge, that's not you both know that's not the way insurance works.
But my question is this, I'm talking about, we'll make it even simpler. They have the capability to post a bond in this case. Why wouldn't they be required to do that?
Because there is a coverage dispute
Okay,
on how much coverage there is. It's being litigated in federal court, Judge. It's being litigated right now in federal court.
and here's my next question though, is that really that important of an issue in this respect? Because there was offers made within the policy limits. So potentially, they can have coverage issues under a traditional sense, but when they fail to accept an offer of judgment,
Judge, you cannot make this bonding issue now based on a coverage issue not in front of you.
but see, what you're missing my point. I'm not basing it on a coverage issue. I'm basing it upon offers of judgment and the ability to cover potentially an appropriate bond under the facts of this case. Is really that simple. And if I'm wrong, if I'm off, go ahead.
If you're making it based on offers of judgment, ostensibly or theoretically within policy limits, you are making your decision on security based on a coverage issue not in front of you. And that's,
But see, you say that, but I've got to push back. I'm not basing it on a coverage issue. I'm basing it on the ability to pay, right?
Judge, I forgot to mention a lot of those cases, Mr. Polsberg cited more. We cited 5 or 6 cases that held that the more does not apply when you have insurance coverage. That rule just flat out doesn't apply when there's insurance coverage. And I could go through the case.
That's why, you know what,
Right.
I don't
I
mind
did
saying it.
this a lot.
Yeah, but
And we have
I'm not
been in
going to make a decision right now, Mr. Posenberg, because I agree with you. I have to make the decisions on the other matters first before I make the decision on this. I agree 100%. But my point is this, I'm just asking you, why shouldn't that be a consideration?
Yeah,
I'm not making a coverage decision. I'm looking at it purely from a straight a scenario where we know what an insurance company has certain obligations. You know that, right?
Not beyond the.
Well,
Judge, you're getting into beyond the policy.
Wait. Can I finish?
All right, I'll let you finish.
Hey, let me finish. Okay, they have a duty to indemnify, right? We understand that. They have a duty to defend. That's the primary basics for all insurance. We know that, right? And so my point is this, and you can tell me if I'm right or wrong. That's okay, because I'm going to think about what you have to say today. I just want to tell you that. And my simple question is this, under the peculiar facts of this case, right? Where you had offers of judgment under the policy limits and there's an excess verdict. And you have an insurance company, because you say, look, Judge, look at it from this perspective. Hanna and Milwaukee, I understand their financial position. I'll assume that's correct. But under the peculiar facts of this case, why shouldn't the insurance company have to post up whatever the bond is? It's real simple.
Well, geez. You're asking me questions
And it's
that I
more,
can only get into
and okay, you don't have to answer.
violating a duty to
No,
one
no,
or the
no, no,
other.
no, no, I don't want you to.
As we point out in our opposition, there's no affidavit from any insurance company saying they won't post a bond. There is no letter from any insurance company saying they won't post a bond. They imply that in the motion, but there is no proof of that in this record.
Do you want an evidentiary issue on that?
No.
I am under the impression, Judge, there are no available limits whatsoever for this claim.
That is a completely different issue than whether they will post a bond.
Right, now I understand.
Will they post a bond or will they not post? a
Well,
bond?
Your Honor, if they,
Someone must know that in this room.
if they
They
post a
won't post a
bond, the insurance company posts a bond, and then we don't prevail on appeal, that bond goes to the plaintiffs.
I understand.
And so, of course,
That's
they're
why
not
you-
going to
that's
be
why you-
willing to post a bond in excess of the amount that they claim they're required to provide in coverage. And that's why we're fighting them in federal court over that coverage issue.
They rejected offers of judgment within the limits. That was their decision. That's.
Judge, you cannot make the decision here based on.
I'm
that.
not making any decision here, but I want to make sure the record's clear. I just asked a rhetorical question for an answer, and I still haven't gotten an answer because I just, it seems to me, and like Mr. Kemp says, Judge, look, there's the cases they're relying upon. There's an exception for insured.
There is an exception for that, and I've been in that situation
The
many
insurance
times.
amount is so limited, and these bad faith rights are not worth anything. Why are they fighting for them so much? Why are they fighting for the bad faith rights so much if they're on the other hand saying, oh, there's only 1 or 2 million worth of insurance coverage?
There's not even that.
Okay, if there's not even that, Your Honor, why are they fighting for these bad faith rights so much? Now they're saying that the
Because
value
I
of the
brought-
asset is less than $1 million. That's what she's saying.
I can't,
He's
Judge,
saying the value
he's
of the
trying to
asset.
get me to comment on the value of the asset
And
of
Mr.
one of my
Polsenberg, I don't
clients
want you to,
suing the other.
Mis- mis-
That's exactly what
But
he's
Mr.
trying to
Polsenberg-
do to me today.
Mr. Polsenberg, I don't want you to go down that rabbit hole. You don't have to. You don't have to.
All right, let me go back to my argument.
Yeah, but I just asked just a rhetorical question. I just wanted, and you're saying, Judge, you can't consider that. I'll accept that response. That's all.
But I think you are considering that.
I haven't made a decision, Mr. Polsenberg. I know you want to make that type of record, Judge, where you're considering this. I'm
Make
pushing.
that record, Judge.
Well, for the record, Court of Appeals and or Supreme Court, I'm pushing back on that argument because that's not my decision and you'll get it in writing. So we'll be real clear on that.
So counsel's coming in here and say what's truly happening. They keep saying, I'm trying to protect the insurance company instead of the insured. I've brought in the insured separate counsel. They say that I want to sell these rights later. No, I never said I wanted to sell these rights later.
The attorney we negotiated this weekend on behalf. of-
Oh,
said
no,
that they
now
wanted to sell
we're
rights.
bringing in settlement negotiations.
Well, you brought in
This
the,
is-
you said you never offered to sell them. You did offer to sell.
I don't mind saying this for the record. I just want to make sure the record.
I never,
Can I
he said
finish?
that
Can I
I
finish?
said this,
Can I-
I never said I wanted to hold on to those rights.
Let me finish. I'm not considering any settlement discussions or any of those things in making my decision. I just want to make sure the record's clear. So I'll push back on that one too. But go ahead, Mr. Posenberg.
Right,
'Cause I
he
do
said
wanna
that
hear
he
it.
doesn't want to own an instrument company. Well, that's what we are, Judge. So clearly he's picking and choosing assets. I think the stay has to be about everything. You can't pick and choose. And he's saying he's going to give me everything except that. No, for 45 days. He's giving me nothing, Judge. You need to decide the stay issues under Nelson. And it should be a stay of all execution under these circumstances, and you can limit our ability to divest. He ended with, I haven't been able to show the irreparable injury. Well, we have this in our brief. The irreparable injury under Nelson is that something will happen in the future that will put the judgment creditor in a worse position. That's the irreparable injury unless they get security. They won't be in a worse position. You can order us not to assign the cause of action to anyone else. There is no irreparable injury. The Supreme Court said we have to maintain the status quo, and that's what I'm asking you to.
Here's my last question. Mr. Kemp brought this up because I'm going to take a look at these cases. He said, look,
Oh, I
Judge.
didn't address that.
Yeah, please. That's what I want you to address.
So yes, there are cases that say, and in fact, I've been in cases in the 8th Judicial District Court where a carrier will come in and say, look, we have X amount of available insurance. We will post that as a bond. And in those circumstances, yes, you can. But I am under the impression that there is no available insurance in this case, or else I would have been making the argument that we can do it. But I'll tell you what we could do, Judge, to latch onto Hannah's argument under Chapter 20. If you say have us post a bond of $1 million under Chapter 20, I will see if we are able to do that.
Is that it, everyone?
That's it, Your Honor. I can prepare an order and give it to Mr. Polsenberg. I'm cognizant of the fact he wants
This,
to bring it to the Supreme Court.
excuse the French, but this is a fait accompli. You.
No,
I
no.
don't-
In the event you rule in our favor.
No, here's what I'm going to do. And it's really this important. It's important because I listened to Mr. Reynolds. I'm not going to make a decision until I make a decision on the prior motion, right? And number one. So you don't have to remind me of that. Secondly, what I'm going to do is this. I don't know what I'm going to do. I'm going to take a look at some of the cases that have been cited by both parties. I do understand this is an insurance coverage case and what's going on there. I'm not going to try to do anything that will impact what the federal courts are doing. I just want to make sure I'm clear on that. And I'm just going to go back to the rule and I'm going to issue a decision. That's all.
I would like, if you do not give us the whole stay we're asking, I'd like a 30-day interim stay so I can go to the Supreme Court.
I understand. Okay.
Can I do the fait accompli and say, okay, you're giving me a 30-day interim stay?
I'm not doing anything until,
To the judge.
wait, I'm not doing anything until I decide the prior motion's pending, and then I'll do the stay issue after that. Mr. Reynolds, you have a question, sir?
Thank you, Your Honor. So am I understanding the court's decision today correctly that at least there is I call it an intermediate stay on the April 4th deadline in the next 2 days that the court will grant while it takes and makes decisions on the pending post-judgment motions, as well as Milwaukee and Hanna's instant motion before the court today?
I think that's fair.
And in that order, you will tell us how much of the stay we have.
If you want a 10-day stay, I will stipulate to a 10-day stay for judicial efficiencies.
No, that's not what I'm asking for. So
What are you asking for, Mr.
if you're giving us an interim stay till you decide, will you in that order give us then an additional period?
I won't say yes or no until I issue that order.
Thank you. Drop up the 10-day stay and get it to Mr. Polsenberg.
Oh, yeah. No, there'll be, no, I'll make it clear.
I asked for 30.
No, there'll be a stay until I issue my order. How about that?
Right, and I'm asking for a
And the
stay.
reason why I think that's important, I don't want to rush. I'm in trial right now, but I want to make sure I get, because yeah,
In Your Honor, again, so I know there's been some conversations that the
it's in place. Yes.
The April 4th, excuse us, April 4th deadline is stayed until extended. Thank you. Until the court rules on both the instant motions today from Milwaukee and Hanna, as well as the 8 pending post-judgment motions and issues written orders in those.
Right.
Thank you, Your Honor.
Thank you, Your Honor.
That's the cleanest way to do it, Mr. Gunn.
Thank you.
Thank you. Have a good day.
Okay.
Thank you, Your Honor. Always fun.
Always fine.
Your Honor,
We have one more matter to do.